In today's video, I want to share with you or discuss just a couple of things which I see occurring with employers, small employers, and a couple of mistakes that they make. So there's really two aspects to it. One is an employer, maybe a good employer with a good track record, may have no issues, employment law issues, no employment law claims against them over a good period of time. And then out of the blue, they have one or they have two. And their difficulty is that they are ignorant of their entitlements and their rights and their obligations. And they're ignorant of what their rights are as opposed to the employees, and they may act hastily. They may simply look to settle something where the circumstances may well be that they could easily defend the claim, or they may rush into it and make matters worse by making some damaging admission or by taking some step that may in fact propound or increase the alleged stress or grief or whatever on the employee. But essentially what I'm talking about is the ignorance and the lack of knowledge and the lack of awareness and the lack of experience of the small employer who has had a relatively stress-free, trouble-free, claim-free existence to date. They are at risk of making mistakes simply by reason of not having the experience in an employment-related dispute. That's the first mistake I see small employers making, particularly small ones who have had no issues. The second issue I see, the second mistake that I see small employers making, and indeed other employers, but more so small employers, again, employers who don't have that many claims to deal with from time to time, and that is the question of being good employers, being popular. In other words, they see 2 or 3 claims against them and they essentially take the view that, look, everybody knows I'm a good employer, I'm a popular employer, the employees like me. Last Christmas I brought them out and I gave them a slap-up meal in the local hotel or whatever. During the summer we have team building and I look after all my staff really, really well. And I'm most surprised about these claims from this employee, and I am very, very taken aback because, as I say, I'm a good employer. The mistake that's being made here is that the question of being a good employer, the question of popularity, doesn't really arise when it comes to the WRC or the Labour Court or indeed the civil courts. The fact of the matter is there is either a legal and valid and justiciable and winnable claim against you or not. So to make that concrete and to make that specific for you, let's say the claim against you is in respect of, say, public holiday entitlements and annual leave. The fact of the matter is that if you actually look at the claim that the employee is making, the leave and the public holiday entitlements were either given or granted or not. And the fact that you brought employees out at Christmas for a slap-up meal, or the fact that you went on a team building thing during the summer on some golf resort, is immaterial. The fact of the matter is that the claim against you is for failure to pay in respect of public holidays and failure to pay the proper annual leave. And your claim is going to be won or lost on that basis. So don't get caught up in the notion that somehow it's a question of being a good employer or a bad employer, or the notion that it's a popularity contest. It's not. There is a claim against you. There may be a number of claims against you, and you need to take a cold, hard look at those claims, perhaps with the assistance of an advisor, but you need to look at the claims one by one and see whether they are defendable and winnable or not. And if they are, well and good. If they're not, but as I say, the question of being a popular or good employer really doesn't arise. The claim will stand or fall on its own 2 feet. Hope you find this video useful. If you do, and if this sort of thing rings your bell and floats your boat, then you may be interested in subscribing to my YouTube channel.